I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are rolling into compilation 115. Yes, you heard it right. We are already on number 115, and we're going to be in 6 different judges' courtrooms on today. Got a few different judges to cover on this compilation. Before I give you the rundown on those judges, just know that there will be no commentary at the end of this. Chapters will be added for your convenience. As always, don't forget to like, comment, share, and subscribe. It is much appreciated. And now let me give you the rundown on those judges. First, we will be in the courtroom of Judge David Stansbury out of the state of Ohio. Second, we will be in the courtroom of Judge Mara Rozanno out of the state of Washington. Third, we will be in the courtroom of Judge Rochon, also out of the state of Washington. And for these last 3, they're all going to be coming out of the state of Michigan. Fourth is going to be Judge Lisa Martin. Fifth, it is going to be Judge Joseph Slaven. And last but not least, we will be in the courtroom of Judge Richard Hillman. Thank you as always, guys, for everything that you do here on the channel, all of the comments and the encouragement to keep these compilations going. I think you guys are more excited about them than I am. And listen, we're going to keep trucking until we hit that next milestone. So listen, let's go ahead, guys, and jump into number 115.
Lincoln County Municipal Court is reconvened.
Please be seated. All right, we are on the record in case number 25 TRD 01258, captioned the State of Ohio versus Jeremiah Mackey Jr. That's you, sir?
Yes, sir.
All right, so the record should reflect that the defendant is present in the courtroom today. Miss Yeager is here on behalf of the State of Ohio, and this matter is scheduled for a trial to the court. The defendant is charged with 2 counts of involving driver's license violations. One is driving under a OVI suspension, and the other is driving under a it looks like it says security on the citation, but according to the new Albany Municipal Code, it's basically just driving under a forfeiture.
What I have is a financial responsibility.
Yeah. So the driving under an OVI charge, or under an OVI suspension charge, is a first-degree misdemeanor. Carries up to 180 days jail, up to a $1,000 fine, and up to a 1-year license suspension. Does carry mandatory minimum penalties of up to, or of at least $250 fine, a 1-day license suspension, and at least 3 consecutive days in Lincoln County Jail. The other charge is an unclassified misdemeanor, I believe, is it not?
Yes.
Yeah, so it doesn't carry any potential jail time. And either way, if the defendant were to enter pleas of guilty or be convicted of the offenses, they would merge for the purposes of sentencing. So there'd only be 1 conviction. Ms. Yeager, is the state ready to proceed with trial today?
Yes, Your Honor. However, Mr. Mackey informed us he actually wanted this set for a jury trial, not a bench trial today.
All right. And Mr. Mackey, what do you have to say about that?
She is absolutely correct, Your Honor. Also, I shared with her as well. I have documents, if I could serve the court.
Why don't you just tell me what you have there first?
These documents that I have is referring to a removal that's been passed up from the clerk, and as well, my case is in fact on an appeal at the moment.
On appeal where?
I'm sorry.
On appeal where?
It's an appeal.
In what court? Is what I'm saying. Where have you filed an appeal?
The Court of Appeals,
Okay, which district?
the 10th District.
Okay, now that covers Franklin County, and we're in the 5th District Court of Appeals.
I'm sorry, it's the 5th District. You're absolutely right. It's the 5th District. I have
I'm assuming that your appellate paperwork is similar to what you've been submitting to the court. That's what it looks like.
that one or this.
But just in general, all of your filings with this court are on this. It's kind of a unique. Well, the documents are unique in that they're gray and they're typed in all caps, and One of them, it looks like, from what you just filed this morning, was filed in the United States District Court in the District of New Jersey in the Newark Division. And this is obviously Newark, Ohio. Well, here's what I will tell you, Mr. Mackey. You do have the right to have a trial by jury, but in order, in a what we call a petty offense, and a petty offense is anything punishable by less than 1 year in prison, a jury trial is not automatic. It has to be demanded. And Rule 23 of the Ohio Rules of Criminal Procedure require that that jury demand be made not less than 10 days before the scheduled bench trial. So your request for a jury trial would be untimely. Now, I'll entertain a position from the state in that regard. Do you intend to represent yourself throughout, whether you have a bench trial or a jury trial? Or did you want the court to, or are you going to ask the court to appoint an attorney to represent you?
Represent myself, Your Honor.
Okay. Well, I'm going to go ahead and I'm going to deny what I construe to be a motion to continue for the purpose of setting the matter for a jury trial because the matter's been pending for quite some time. Let's see, all of February, all of March, and now halfway into April. And so the defendant did have an ample opportunity to submit a demand for trial by jury, but that demand was made in an untimely fashion today. So the record will reflect that the motion was made, but the court denied that. So your options at this point, Mr. Mackey, are to either have a trial. The state has indicated it's prepared to proceed, and you can obviously represent yourself. You have the right to, if you wish, to change your pleas from not guilty to guilty or no contest. But I do not believe the state is inclined to dismiss the charges. Is that correct, Ms. Yeager?
Correct, Your Honor.
All right. So how would you like to proceed? Would you like to have your trial today, or did you want to change your pleas from not guilty to guilty or no contest?
Your Honor, if it pleases the court, I motion that this case be continued and or stayed because the case is now on an appeal in the 5th District Court of Appeals. Also, the case has been petitioned removed to the Ohio District Court under case 223 CV 02962 JLG CHG and to the New Jersey District Court under case 224 CV 03934 MEFJBC. The court's jurisdiction is divested until those courts determine otherwise.
Well, actually, none of that is true. Basically, number one, your paperwork from that purports to be from the federal district court doesn't look like pleadings from the federal district court. Those are plain white paper with the case number in blue up at the top of the page, and that's not how yours are captioned. Furthermore, as far as jurisdiction is concerned, this court does have jurisdiction because this is an alleged violation of the traffic laws of the city of New Albany that is alleged to have occurred within Licking County. This court has jurisdiction over traffic offenses that are alleged to have occurred within Licking County. And by being here today and by entering pleas, you've waived any objection to personal jurisdiction over you. All right?
Your Honor, I object on this bench trial. I do want a jury trial.
Okay, and as I've already explained to you, you did not make your demand in a timely fashion, so the motion to continue and the request for a trial by jury is going to be denied. It doesn't sound to me like you don't want to, I know you don't want to change your pleas from not guilty to guilty or no contest, so at this time I'm simply going to order or ask the prosecutor to call their first witness.
Thank you. The state will call Officer Kors to the stand, please.
Officer, please come forward and be sworn. Oh, actually, before he does that, Mr. You can have a seat, but Mr. Mackey, you indicated that you do wish to represent yourself, correct? Is that right? Okay. So you have the right to be represented by an attorney by hiring one of your choosing. You're also eligible to ask the court to appoint an attorney to represent you at no cost. If you qualified based upon your income, your expenses, your household size, the court would appoint an attorney to represent you. However, if it's your intention to represent yourself, it is necessary to execute a written waiver of the right to counsel. 1258. So I'm gonna have the bailiff hand to you a form entitled attorney waiver. I'm just gonna read it into the record in open court for right now. It says, it's captioned attorney waiver, and it says, in open court and on the record, I hereby waive my right to an attorney in this case. I've been fully advised of my right to be represented by an attorney, including my right, if applicable, to have an attorney appointed by the court at no cost if I qualify. I agree to proceed without an attorney at this time. I have been advised of the charges against me and the maximum possible sentence that they carry. I've also been advised if there are any mandatory minimum penalties which might apply. And then it says, in witness whereof I have hereunto subscribed my signature this 11th day of April 2025. So if it is your intention to represent yourself and to waive your right to an attorney, go ahead and sign by the X there, but do please read that, because I'm going to make sure that you understand what it is.
Yes, that
Been objected to this. I object this trial.
I'm sorry, I didn't hear what you said.
Refusing to sign this, Your Honor. At this moment, I'm not refusing to sign it. This court jurisdiction has been divested.
Okay, well, I've already ruled on that, and that can certainly be appealed at a later time, but this part of the case, this portion, or this part of the process is going to go forward. If you later appeal, if you're found guilty, I'm not saying you will be, but if there's a conviction that's entered, you have the right to appeal to the 5th District, arguing that this court never had jurisdiction over you, which means basically this would all not count. But you don't get to make, I've already made the determination that the court does have jurisdiction over you. If you don't want to sign that form, obviously I can't make you do that, but I will declare what's called a constructive waiver of counsel. And what that means is you've said out loud that you wish to waive your right to counsel, that you want to represent yourself. I'm going to accept that as a valid waiver of counsel, even if you don't wish to sign that. So, Ms. Kyle, if you'll bring this back to me, and for what it's worth, Mr. Mackey, this was filed with the court, and I do have a copy of that, and I did look at it, okay? All right, very well. Please swear in the witness.
You solemnly swear or do you affirm that the testimony about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I affirm.
Please have a seat, sir. For the record, you're going to give your name and spell your last name.
Officer Michael Coors, Cohrs.
And the address to your precinct.
50 Village Hall Road, New Albany, Ohio, 43054.
Thank you, sir.
Thank you. You may inquire.
Officer Force, how long have you been with the New Albany Police Department?
Over 6 years.
And were you so employed on January 29th of 2025?
Yes.
And were you working that day?
Yes.
What shift or hours were you working?
Second shift, it's 2 p.m. to 10 p.m.
And were you wearing a uniform of the day like you are in court?
Yes.
And were you driving a marked cruiser with a working visible light bar?
Yes.
And what were your duties that day?
I was working standard patrol. I would believe I was on Zone 3, which is the Licking County side of New Albany.
Is that for like traffic enforcement?
Correct.
And what kind of training have you undergone for traffic enforcement?
I was trained at the Columbus Police Academy over 2 weeks of traffic enforcement, to include all traffic laws and proper traffic stops and procedures.
And as of January 29th of 2025, were you up to date on all continuing education, training, and certification requirements?
Yes.
I'm going to draw your attention to about 4:50 p.m. Whereabouts were you on patrol at that time?
I was on Beach Road heading southbound just north of State Route 161.
And is that in the city of New Albany in Licking County, Ohio?
Yes.
While on patrol, what first drew your attention to the defendant's vehicle?
As he was traveling northbound, making a left turn onto the State Route 161 westbound on-ramp, I observed he had dark tinted windows, which initially drew my attention. And then as he passed me, I made the right-hand turn, drove behind him, and entered his license plate.
Okay, and did his license plate, when you ran that, return anything?
It did. It turned through my mobile computer, through our leads program on there. I observed that his license plate had expired, or registration, I should say, expired on July 8th of 2024.
And so when you approached the defendant for the stop, did you inform him as to the reason for your traffic stop?
I did.
And did he have anything to say about that?
He stated he was aware that the registration had been expired.
Okay. And did he have a driver's license for you too?
He had an identification card.
An ID card? Okay. Were you able to then go back to your mobile unit and run his driver's license status?
Yes.
And what did that return?
I observed, again, through my computer system, that it showed he had multiple active suspensions, one of them being the OVI suspension that he was cited with, as well as the 2 non-compliance suspensions. On my system, the reason why it was shown on the citation as a security suspension, that was the label, but per what I read through the system there, it was the financial liability.
Nothing further for this witness at this time, Your Honor.
All right. So, Mr. Mackey, you have the right to ask this question witnesses. You have the right to ask this witness questions if you wish, but you're not required to. And once the state's rested its case, you'll have the right to present evidence on your own behalf. But this portion of the trial is just for questioning. Do you have any questions for the officer?
No, Your Honor.
All right. Officer Kors, you may step down. Any additional witnesses on behalf of the state?
No, Your Honor. Subject to the admission of Plaintiff's Exhibit 1, the state would rest.
All right. So, Mr. Mackey, the state is asking me to admit the certified BMV records into evidence. If I grant that request, that means I'll be able to consider that in making my decision about whether or not the state has met its burden of proof beyond a reasonable doubt. You have the right to object to whether or not that comes in. Do you have any objection to the court admitting that as an exhibit?
To this bench trial, Your Honor, I do. I object to this bench trial, Your Honor.
Okay, well, we've discussed that already, Mr. Mackey, so at this time, I'm just asking whether or not you have an objection to the admission of the exhibit.
Yes.
And on what basis?
This court does no longer has jurisdiction, Your Honor.
Okay.
I respectfully.
Well, that's non-responsive to the court's question. I'm going to go ahead and I'm going to reflect that the defendant is objecting to the admission of State's Exhibit 1, but I will admit that over the defendant's objection. Does the state rest?
Yes, Your Honor.
All right. Now, Mr. Mackey, the state has rested its case. In our system of justice, it's always the prosecution's burden to prove guilt beyond a reasonable doubt before a person can be convicted. A defendant is never required to produce any evidence, call any witnesses, introduce any exhibits into the record, or even testify on their own behalf. And if they don't, I don't hold it against them. It doesn't lessen the state's burden of proof. It doesn't diminish your presumption of innocence. But you do have a right to present evidence by calling other witnesses, introducing exhibits into the record, and testifying on your own behalf. If you elect to take the witness stand, however, you will be required to either swear or affirm to tell the truth in giving me your side of the story. And when you're finished giving your side, you will be required to answer any questions that the prosecutor might have. So other than yourself, do you have any witnesses that you'd like to call today?
No, Your Honor.
Okay. And do you wish to testify on your own behalf?
Your Honor, I object from this bench trial. Respectfully, Your Honor.
Okay, and I've entertained that objection on more than one occasion now, and I've already overruled it, so it's not necessary to do that. But you are creating a record here, Mr. Mackey, so that we're recording all this. You'll certainly have the right to obtain a transcript of the proceedings and pursue your appeals regarding the jurisdiction issue. But again, my question that I'll ask one last time is, do you wish to testify on your own behalf?
No, I'm fine.
Okay, very well. Well, the court's heard testimony from Officer Kors, which finds to be credible, that he was on duty on the date in question, that he executed a traffic stop upon discovering that the registration on the vehicle was expired, that he made contact with the driver, who he's identified as the defendant, and upon reviewing the information provided by the Bureau of Motor Vehicles, determined that he was under both an OVI suspension as well as a Financial Responsibility Act suspension. The court, furthermore, has admitted into evidence over the defendant's objection, admittedly, a certified copy of the defendant's driving record through the Bureau of Motor Vehicles, and it does in fact list both the noncompliance suspension as well as the OVI suspension, and reflects the expiration date of the registration as being prior to the date of the traffic stop. So I do find that the state has met its burden on all three counts, and I'll go ahead and enter guilty findings. You have the right to make a statement today, Mr. Mackey, before I make any decisions regarding your sentence, but you're not required to. Is there anything that you would like to say other than the jurisdictional issue?
No, Your Honor.
All right, thank you, Mr. Mackey. Miss Yeager, did the state wish to be heard regarding the matter of sentencing, and which driving under suspension charge did the state wish to elect to have the court enter a conviction and sentence?
We would elect to undergo the OVI suspension, Your Honor. And the defendant does have minimal history, so we would just recommend the mandatory minimums on that.
All right. It's kind of customary for me to ask questions of the defendants about their personal circumstances. If you don't want to answer, that's fine. Do you work? Do you have a job?
Yes, Your Honor.
What kind of work do you do?
HVAC, sheet metal, as I told the officer that had pulled me over.
Is that what you were doing that day? You were working out at the warehouses? Okay. Do you work for yourself? Do you work for yourself, or do you work for a company?
I work for a company.
Okay. How long have you worked for them?
It's been 3 years. I've been in a skilled trade.
Okay. Well, here's the thing. One of the reasons why I'm asking you these questions today is, as I mentioned earlier, at the beginning of our proceedings, the court is required to impose at the very least a 3-day jail term. I don't want to cost you your job. Do you work Monday through Friday?
Saturday, Your Honor.
Monday through Saturday? Okay. We normally do not have, well, let me go ahead and print out the sentence first, and then we'll talk about that. When you got pulled over that day, Mr. Mackey, you were just given your citation and then you were free to go, right? They didn't take you to jail, did they?
Correct.
Okay. All right. As far as the registration is concerned, the fine on that charge is going to be a $25 fine. On the driving under the OVI suspension charge, the court's going to impose a 3-day jail term, a $250 fine, and a 1-day license suspension to be start today and as of midnight. Costs will be assessed. Now, the reason I was asking you about your work and everything else is, as I said, I don't want to cost you your job, Mr. Mackey, but I don't have any discretion when it comes to those 3 days in jail. Normally, we require defendants, I'm assuming you don't want to go today, right? No. Okay. So it's customary for the court to grant what we call report dates. Some courts call them enforcement dates. And typically, we require that the defendant report here to the courtroom. But since my colleague, Judge George, took the bench, we now have the option of having folks report directly to the jail. And that's important for one reason. If you had to report here, you'd have to report on a day that the court's open, so a Monday through a Friday, all days of which you work. But if I order that you report to the jail on a Sunday, at least one of those days, you won't, of the 3 days, you won't be missing work, okay? Would you like for me to grant you a report date to the jail on a Sunday? I mean, I know you don't want me to impose any jail at all, but under the circumstances, would you prefer that I make it so that you report to the jail on a Sunday so you only miss 2 days of work? Okay. All right. Let's set it out a little bit just to give you some an opportunity to make those arrangements with your work. Let's go ahead and I'm going to have you report directly to the jail on Sunday, May the 4th. And that's located at 155 East Main Street here in Newark. And the bailiff will give you all the information that you need. I said, what did I say, the 4th?
Yes. Yes.
Okay. And that's going to be at 11 a.m., Mr. Mackey. And then you'll get out 3 days later. Now, can I speak bluntly to you? So you're not the first person who's come through court with these arguments that you're making regarding jurisdiction and the right to travel and things of that nature. I don't know whether you genuinely and sincerely believe that that's the law. I'm here to tell you that it's not. But even if you do, I got to tell you, a lot of times folks who espouse these arguments just continue to find themselves in court and they don't win against the system. It may be unfair in your mind. I get that. I understand. But I just want to give you a word of caution that, you know, if you do get cited in the future with any traffic violations or even criminal offenses, making these arguments is not going to work out in your favor. It's not going to help your situation. You know, you can be as frustrated and angry at the system as you want. The law is what the law is. But I would just recommend that in the future, you know, just deal with it regularly and move on. You know, the only thing that you need to do is, you know, comply with the driver's license laws, and you won't have to worry about having to listen to guys like me anymore. Okay.
All right. It's off the 11 o'clock calendar. Mr. Calzada, could you please turn on your video for me?
Yeah, hold on one second.
All right. Good morning, Mr. Calzada. You're here for arraignment, so could you please tell me your full legal name?
I don't know how that has anything to do with the case. My name.
Well, Mr. Calzada, I need to confirm who you are. So could you
Here
please
I
tell
am.
me? Well,
I'm here
please tell me
physically present, right?
Mr. Calzada, could you please, what is your first name?
My first name? Well,
Mhm.
it could be anything, right? I could change my name at will, right?
All right. I'm going to set this matter over for an in-person arraignment, and Mr. Lohr, you'll have law enforcement standing by. All right?
Well, there you are.
All right. So, Mr. Calzada, I will set this over. You will appear in person at the Bothell Municipal Court for arraignment.
I don't even consent to that.
I'm going to set this to December 31st at 1:30 in the Bothell Municipal Court in person. You will need to be there for arraignment, okay? So I will see you in person at the Bothell Municipal Court at that time, all right?
Looks like there's no free will then.
So
then what am I doing here then? Hold on, what am I doing here?
well, right now you are not responding to my questions. So
Well,
I'm
you're
going
not
to have you
responding to any of my. I don't have a problem of answering any of your questions, but I have a couple questions first. I have to understand too. I don't understand what's going on. I don't know everything. I'm not
then
perfect.
I'm in person so that we can be sure that you understand what's
All
going on.
right, great. I'm glad. It's definitely implied, isn't it? It's not expressed. It's implied.
December 31st at 1:30 in person.
December 31st at 1:30, I'll be there.
Very good. We'll see you then.
Your Honor, next we can take Aaron Thomas.
Okay.
And Your Honor, after speaking with Mr. Thomas, he was not comfortable with me signing the rights form on his behalf, and he would like to have an arraignment in person.
And that's fine. Can you hear us all right, Mr. Thomas?
Yes, sir.
All right, very good. This is 3A757954 and 3A757955. When can we arraign him in person, please, Carrie?
Your Honor, due to the holiday schedule, the earliest would be December 7th at 2:30.
Okay, Mr. Thomas, write down December 7 at 2:30 and confirm when you've done that.
Okay. 1 second here.
No, no problem.
Yeah, I got my phone stolen last night, so I gotta do it on my computer here.
Yeah, no problem. Just let me know when you got that in there.
All right.
Did you get it in there?
Not quite yet. I'm opening up.
Okay. Just let me know.
Thank you, sir. Okay, you said December 7th at 2:30, correct?
Right.
All right, yeah, I got you.
And it's here at the Bothell Municipal Court, Mr. Thomas.
Okay, thanks. All right, yeah, I got it down.
Thanks so much for writing that down. And keep that, don't erase that. That's your notice now. You got an actual notice, right?
Well, oh yeah, I mean, I have it on my computer here.
Fantastic. Thank you, sir.
Hey, I hope you have a good day.
The court's found probable cause for the prosecution is charged, so subject to you and your lawyer readdressing this, you're to be here on time for all scheduled hearings, commit no criminal acts, don't drive until you have valid license and insurance in your pocket. Any questions about all that?
No, I wasn't driving though.
Good. Please don't unless you have license and insurance in your pocket.
I would never drive. Yeah, I would never drive.
That's fantastic. Glad to hear it. Thank you, sir.
You're welcome.
All right. Next case.
Okay, cool. Have a good day.
You too.
Mr. Frank Michaud, who is present here on Zoom. Mr. Michaud, can you state your name for the record?
For the record, I am the beneficiary of the Frank Anthony Michaud Jr. estate. I am the authorized representative, and I appoint you, the judge, as the trustee, ma'am.
Mr. Mohammed.
Good morning, Your Honor.
Good morning. My apologies for interrupting your breakout, but I want to get some of the matters that are already on screen and ready cleared out. Mr. Sullivan and Mr. Moshu.
Ready?
Thank you. Today is a day and time set for the probable cause conference. How are we proceeding, Mr. Sullivan?
Judge, as I was saying earlier, Mr. Michaud has indicated that he'd like to represent himself Hopefully, if it's acceptable to him, I can remain just sort of present for the proceedings in case he has any questions. My recommendation to him is that we demand all of the discovery in the case. We have paper discovery. I'm forwarding that to him, but we don't have any of the digital discovery. So we are requesting all of that. And then I'm also recommending to Mr. Michaud that we schedule the case for a preliminary exam. And I'm happy to be present for that as well.
Mr. Mohammed?
Yeah, Judge. So I don't believe we had an attorney on record on file for this case, and that's probably why discovery wasn't sent over. Also, I believe we're missing some stuff as well, and we're in the process of getting them as well. If Mr. Sullivan's going to be the attorney moving forward, we'll send it to him. But if he's no longer going to be retained, then I don't know. I don't think it's useful to send it over to him. So if we can know who the attorney is moving forward, we'll send that discovery to that attorney.
Mr. Sullivan, are you formally making a request to withdraw from this case?
Judge, maybe my request is that we have an adjourned PCC for me to meet with Mr. Michaud and discuss this further, unless he'd like to make a decision just here and now. Perhaps one adjourned PCC and some additional time for Mr. Michaud and I to discuss this. We can come up with an arrangement where I'm at least receiving the discovery, on his behalf and trying to facilitate this for him. But I do want to respect his desires to represent himself.
And Judge, the people would have no objection to any adjournment. And if Mr. Sullivan is the attorney moving forward, please just send me an email letting me know, so that way I can make sure digital is sent to you.
Mr. Michaud, were you able to hear Mr. Sullivan just now?
Yes, ma'am. I heard everything that was said.
And was that a reasonable way to proceed at this time? I'm sorry.
Oh no, I still stand as being the beneficiary of the estate and point you as trustee, and demand that this alleged debt, is discharged from my account, from my exemption account. As I sent over copies of my birth certificate, as well as an affidavit. I don't know if you received it, but it's been sent certified mail. And that is me making this special appearance today. And with the challenge of the jurisdiction, since I have not really been fully told, or I really don't understand really the allegations or the nature and causes of this allegations on my estate.
Sir, I'll interrupt you just for a moment. In as much as you've indicated that you don't understand or have not been fully apprised of the nature of the allegations, we will adjourn this matter over for 3 weeks. That adjourned PCC date will be
December 20th at 8:45 with Judge Oakley.
The adjourned PCC date will be December 20th, 2023 at 8:45 a.m. That's in person in courtroom number 2 with Chief Judge Brian Oakley. And between now and then, Mr. Sullivan, you have the opportunity to speak with your client, bring him up to date on the status of these matters and explanation of the charges against him. And if you want to, at that time, have a conversation with Judge Oakley about how you be proceeding or not proceeding as counsel, that would be the time to do it. Is there anything else, Mr. Mohammed?
Nothing from the people, Judge. Thank you.
Anything else, Mr. Sullivan?
Judge, I apologize for the inconvenience, but I am in a sentencing that morning of the 20th. I don't know if does the court have availability like later in the morning. I could make it work late morning on the 20th or in the afternoon on the 20th.
10:45.
That'd be much better. Thank you very much.
Thank you. 10:45 on December 20th. That concludes this matter. You're free to go. You have a good afternoon.
Ms. Sobe, you're here on the Martin matter, correct?
Yes, Judge.
Let's go have a conversation outside.
He'll be assistant. Okay, so everyone,
All right, today is the date and time set for a hearing in this matter with regard to a bond violation. This is case 242448 SM. People versus Eric Martin. Everybody hear me?
yes, good morning, Judge. Donna Silva on behalf of the people, P87439.
Morning, Your Honor. James Gazicki on behalf of Mr. Martin, Your Honor. I have a motion to make.
All right, go ahead.
Your Honor, I'm making a motion to withdraw. I've had contact with Mr. Martin before in other matters, and there's no attorney-client communication in this matter. We're talking about different things, and there's just no way of moving forward that I could adequately represent him, Your Honor. So I'm asking to withdraw.
All right, your motion to withdraw is granted. Mr. Martin, would you like a different court-appointed attorney?
Yeah, I guess so, since he shows his willingness not to want to do his job and help me out, and he's misstating, making false statements. You're talking about there's a lack of communication. It certainly ain't on my part. I was pointing out to him relevant defenses. He just didn't want to do his job. That's clear what he made of me. So,
Mr. Martin, I have found Mr. Gazicki to be a very competent individual, a very competent attorney in many, many cases. I've seen many trials, hearings, motions, practicing in front of this court, and I find him to be very competent. If you make one more negative comment about him, I'll hold you in contempt of court. I don't do that. We don't act like this isn't the Jerry Springer show. This isn't going to be a bunch of name calling. You're going to knock it off. Knock it off, Mr. Martin. I'm done with everything and you keep doing all your little negative comments, things that you want to say about people. And you think you're the smartest person in the room and that you have some sort of special Juris Doctorate, I guess, from somewhere. I don't know, but you don't have the first clue when it comes to things, and you talk about that. And so Mr. Gazicki is saying that he's trying to talk to you about actual legal defenses, and you're trying to bring up some kind of other stuff. And so I'm going to grant his motion. Do you want, all I asked you was this. I didn't ask you to give me a commentary about Mr. Gazicki or what you think he can do, because I've always seen him to do his job every single time he does a file. What I want to know is, do you want another court-appointed attorney, or are you representing yourself? That's it. It's a simple question. Answer simple questions. That's what you needed to start doing, is answering questions.
Yep, one another attorney, but I want to state also that if it was recorded, that we state it would support my allegations.
Boom, time out. Nope, not hearing it. The question is this: do you want another court-appointed attorney? So you're either going to say yes, court-appointed attorney, or represent yourself. Which is what is your answer here today? Because there's only two possible answers here. You either get another attorney, or you can represent yourself if you like. Or if you want to hire your own attorney, you can do that. So there's three things. Are you going to get one appointed, yourself, or retained? Those are the three possible answer choices. What are you going with?
Yes, another appointed one, but without.
All right, there you go. Don't need any more commentary. Don't need any more commentary about it. You have a right to remain silent. You can exercise that right now. So we're going to appoint another court-appointed attorney to you. And the individual who was here as your attorney during your trial, you seem to get along pretty well with him. You want me to reach out to see if he's available?
Well, I don't know who you're referring to.
The guy who was here at your trial. I don't know his last name.
Oh, he's on the other trial.
Yeah, the other trial, not this case. This is the misdemeanor domestic violence case. I'm talking about your driving on a suspended license case, restricted.
Well, I mean, he did for the most part. He did, well, I don't say for the most part, maybe for the most part, but there's some things he didn't do neither. He should have. He didn't raise my right to travel defense. So
Yes or no? Yes or no? Is he somebody that you think you can get that you can communicate well with?
I guess we'll give him a try. I guess. Yeah.
Sure. All right. I'm going to appoint or reach out and see if we can see if he's available. So let's appoint.
But now, Slaven, I have some questions for you before we move forward.
All right. So we're going to set that. We're going to set that for a hearing date, and we'll see you then.
Hold on.
And sir, you are Amate Bay, is that correct, sir?
Yeah, I'm a Amate Bay, real party and interest in this matter.
Okay, are you driving a vehicle right now while you're on the hearing?
You said I'm driving a vehicle. Yeah, you need me to stop? I mean,
I need you to stop, sir. I can't have you driving
give me
while
15
you're.
seconds. I can pull it back up to my family house, and I'll stop.
No, I can't allow you to proceed while you're driving a vehicle.
No, I'm saying I'm parked. I'm filling up parking now. I'm parking, right? 5 seconds. Okay, I'm done, Jan. For a second, I'll call y'all when I get back.
Okay, this matter is scheduled for a hearing.
Do you recall in reviewing your business records if a foreclosure was conducted with regard to this property?
Yes, it was.
Objection, Your Honor, hearsay.
Okay, overruled. You may respond, sir.
On what grounds? So I could maintain the error for the record when I appeal this, if this don't go accordingly?
Okay, it's a business record, sir. That's an exception from.
First-hand knowledge. Was he there at the closing table?
Doesn't need to be, sir.
Your Honor, it seems like you're practicing law from the bench. I'm gonna respect your courtroom, but I disagree. I would disagree as tremendous. So, okay. Court reporter, can you please note that the honorable judge, I'm stating he's practicing law from the bench without facts.
But your objection is part of the record, sir. All right. You may continue, Mr. Dewhurst.
And is this a true, correct, and complete copy of the sheriff's deed of mortgage foreclosure, to the best of your knowledge?
To the best of my knowledge, yes.
And is this sheriff's
objection, Your Honor? Can he vow to that under penalty of perjury? That's the original document.
Your Honor, he stated this to the best of his knowledge.
No, under penalty and perjury, can he contest that that is the original document with the wet blue ink signature? Penalty and perjury.
All right, sir. That's not the question. The question is whether he can identify the document.
Under penalty and perjury, can it be yes?
Sir, you have to stop interrupting.
Penalty and perjury.
You can make an objection, but once you've stated your objection, you have to stop.
Yes, Your Honor.
All right.
And for the record, Your Honor, I do have counsel coming for this next court date. They obtained, as soon as he get back in the country, he will be jumping in to take care of this matter further. So I'll ask if you just give my counsel some time before any permanent decision is made so they can review these books, all interrogatories, so we can make a fair decision. Because I'm not arguing it's a debt, and I've been trying to honor the debt, Your Honor. I'm not arguing that it's a debt. I done did everything possible to honor this debt. They have not been in compliance with it.
And Your Honor, I would object to that, given this would be our third hearing, and he had ample time to get counsel.
Objection again.
All right, let's take one issue at a time, gentlemen. I can't be expected to remember 3 or 4 objections all at the same time. I'm going to overrule the objection on the basis of a business record exception. As to the request to adjourn the matter for Mr. Bay to retain counsel, I'm going to deny that request. Mr. Bay is
on what grounds, Your Honor? Because I never got served directly.
If you stop speaking when I'm speaking, then I will state my grounds. And so
I never requested that. You stated that, Your Honor. This is my first time requesting any adjournment to bring in incredible counsel who can handle this matter fairly on my behalf.
At this point, I don't even see that you have standing to participate in this case, although I guess we will get to the proof on that issue. So,
so Your Honor, you don't have my deed of records right there. You don't have me as a deed owner. You don't have me as a certificate owner in the record. I put all that on the record. So for you to say I don't have standing is kind of unfair from my understanding.
And was that redemption date September 27, 2021?
Your Honor, he's coercing. He coercing Mr. Dewhurst.
Was a government record and or document recorded with the applicable recorder of deeds for this document.
Okay, any objection to that, Mr. Bay?
Absolutely objection.
Okay, and what's the basis for your objection?
He's a third-party debt collector. He's not a real party in interest, and he has no firsthand knowledge of any of the affairs that took place with this mortgage or at this closing table. And that Mr. Dewhurst he's not eligible to bind a corporation. Do he have the status of a CFO or a CEO in that company?
Okay, so the objection is that this witness doesn't have the
Firsthand knowledge to any other matters.
Okay, all right. So the objection is overruled.
And has Carrington ever conveyed any of their ownership?
Objection, Your Honor. Objection.
What basis, sir?
Rightful owner as the title, rightful owner as complete ownership of the property. Can't just take away my interest like that without facts. You guys still have not had no verification of debt. What you have in your hands, Your Honor, we don't reached out. They cannot verify that debt, and they cannot verify that they ever loaned Rachel Brown and Matthew Brown any money for this mortgage. They can't. They can't prove that, and they haven't yet. And I've been waiting. I just want to know if they are real party in interest, are they a real creditor in the amount, so we could handle any financial obligation that's owed. They are yet to prove that. Like you said, I got the deed, and it's sealed by the county records. I have the warranty deed as well, and it's sealed by the county records. Objection. Can you prove I didn't redeem and attempt to redeem? Can you prove that it hasn't been corresponding and negligence on you guys' behalf?
Overrule the objection.
Yeah, the property was foreclosed on and Carrington took control of it.
Okay.
Objection, Your Honor. How can you take control over something that I got the taxes in my name? I've been staying there the last year, and I have the deed and the warranty deed again for the record.
May I ask a question that would help?
You may, Mr. Johnson.
Objection, Your Honor. He's about to coerce him again. The question was clear. He could answer that on his own.
Honor,
he said he had 30 plus years of experience. This shouldn't be his first rodeo. He can answer that on his own.
Was there any redemption made by any party during that time?
No.
And none of your reflect.
Objection.
None of your record.
Objection.
And once again, you have not.
What's your objection?
That's not credible. That's not credible.
I'm sorry. This is not your time to ask questions, Mr. Bay. Mr.
Okay,
Johnson.
let me know when I'm credible to ask questions.
All right. Mr. Johnson, any other questions?
Has Carrington ever conveyed ownership of the subject property to any party?
No.
Thank you. No further questions, Your Honor.
Objection, Your Honor. So Brown and Matthew Brown, not the owner at the time that they
Mr. Bay, this is your time to ask questions. So if you want to ask any questions to Mr. Dewhurst, you may ask questions to Mr. Dewhurst.
Okay, Mr. Dewhurst. Is it not law that 15 U.S.C. 1692G requires verification of any debt?
Your Honor, I object as to relevancy.
Again,
okay, what's the relevancy, Mr. Bay?
I'm establishing bounds for fraud. And since there's no statute of limitation for fraud, I'm going to make sure if they're not the original creditor, that it's fraud.
You didn't respond to the relevancy or how this is relevant.
The relevancy of 15 U.S.C. 1692G, it binds any corporation or anybody who's saying there's a debt or a balance to verify it.
Okay, so this is the time to ask questions, not to argue law.
No, I'm not trying to. I'm asking the question. That was a question.
You have a question regarding the facts for Mr. Dewhurst. Okay, you may proceed.
Yes. So again, Mr. Dewhurst, under 15 U.S.C. 1692G, do you have to verify a debt?
I'm going to have to object again regarding relevancy, Your Honor. This is, unfortunately, he does not have standing to bring any claims of verification.
Objection. I'm a real party in interest. Objection, Your Honor. He doesn't have any standing. He hasn't proven he's more than a third-party debt collector yet.
Your Honor, after the foreclosure period ran,
Your Honor, we don't know if this is credible foreclosure. Can I ask my questions, Your Honor?
All right, gentlemen, you cannot speak at the same time.
Next question. So, Mr. Dewhurst, are you conscious of the verification of that letter that been sent to your company twice that I sent with behalf of Matthew Brown and Rachel Brown that they're yet to respond from. My notary sent it. The notary republic sent it.
Your Honor,
Yes.
I would have to object.
Yes or no?
Sir, you have to let Mr. Johnson state his objection. Mr.
Okay, I'm
Johnson,
sorry.
what's your objection?
Your Honor, she's asking the witness to respond to a vague request if he has any notice, but, you know, I would ask that he would only ask as it relates to the business records, Your Honor.
Objection, Your Honor. I sent that to the business and record department, and I sent it attention to the CFO of the company.
No, Your Honor, I'm not aware of it.
But that's an argument. That's not a question. This is a time for questions.
No, that was in the form of a question. You didn't let me finish, Your Honor.
Okay, well, you can't ask multiple questions within the same question.
Okay. Well, Mr. Dewhurst, what was the problem answering the verification of debt letter? If you have that in the record. So we've been asking for the original.
Objection, Your Honor. He stated that he was not aware of a letter.
You're right. Correct. So I should say then, moving forward, is there a problem producing the original contract with the wet bluing signature from Rachel Brown and Matthew Brown? If you have that in the records.
Okay, so you have a question for Mr. Dewhurst?
Yes, Mr. Dewhurst. Is it fair to say you cannot prove that the original, you don't have access to the original copy of the note of the mortgage?
Yes, I'm
under
sure.
penalty and perjury, do the company have it, Mr. Dewhurst?
So you may ask another question.
And okay, also, Mr. For you, Your Honor. So it's also credible and fair to say he has no firsthand knowledge of anything as well.
Okay, so that's an argument. That's not a question. Okay. So
all right, I'm learning. I'm sorry, Your Honor. Thank you for your patience. So Mr. Dewhurst, under penalty and perjury, can you confirm that your company followed all GAP procedures with this process?
Objection, Your Honor.
Understandable. So I guess the last question, again, I just want him to confirm that Mr. Dewhurst, you have no firsthand knowledge of the of Carrington Mortgage being a creditor in this loan for this mortgage. So that's still kind of broad, Your Honor. I want for the record for him to say, are you guys the creditor, or you don't know?
Your Honor, asked and answered.
No, that's not asking and answer. I'm asking directly. Mr. Dewhurst, is Carrington Mortgage, can you confirm they're the creditor of this loan or this note, or you don't know? And I'm asking that for lawful reasons.
And so by bidding the highest in the sheriff's sale, what interest does that give Carrington then in this proceeding?
We're then the creditor.
Okay. All right.
Allegedly. So that is true if that's the case. But if, Your Honor, or court, if Carrington can never prove they ever issued anything, is it fair or is it lawful to state that they never have the right to say they hit with the highest bidder with anything?
Any more questions for Mr. Dewhurst, Mr. Bay?
Not at this moment, Your Honor.
Okay.
Not at this moment. I'll let my counsel deal with that.
Okay. Does the plaintiff rest?
Yes, Your Honor. But if I may just conclude with a couple things, if that's okay.
Well,
objection, Your Honor. Statement and brief from counsel is sufficient for summary judgment.
And to show that there was indeed a foreclosure sale conducted on March 25th, 2021.
Objection, Your Honor.
And this is final argument, so that you can't object to that.
I'm sorry, Your Honor.
All right. Additional final state arguments, Mr. Bay?
Yeah, again, Your Honor, you know, he's wasting judicial resources coming with this because, again, I have proof on file and on record, correspondence. We try to resolve this matter. At this time, I would like to bring my counsel in. They'll be back in the States in a couple of weeks. And also, Your Honor, can I request that Mr. Johnson put his bond on file? Can I get his bond information, his liability bond for this matter as well?
Okay, no, that's not an issue in this case.
I asked for you to just honor my motion, honor my counterclaim to dismiss this matter because they don't have, it's not a, nobody with real party and interest on this line right now. Nobody with firsthand knowledge is on this court case right now. that can speak and contest to what's going on. So with that being said, I ask to adjourn this matter or dismiss this matter because for failure to state a claim upon which relief can be granted.
An individual who's identified himself by the name of Amate Bey claims to have a possessory interest in the property, though he did not present any proof on the record today of any interest that would make him have standing to contest this mortgage foreclosure and this suit for possession. So based on the proofs on the record, the court does find that Carrington Mortgage Service LLC does have the right to possession, and therefore a judgment of possession against Amate Bey and all occupants of the premises is granted.
What is my time frame to no, can you just for the record, so there's no contract with Amate Bey and Carrington Mortgage in this matter, right?
Sir, I'm not going to explain my ruling to you. I just ordered that the Carrington Mortgage would have the right to get an order of eviction on July 5th, removing all occupants from the premises.
That's fine, Your Honor. I'll make sure it get overruled in a higher court. Thank you.
Okay. All right. That's all for the record. Thank you, gentlemen.
Thank you,
Your Honor. Have a nice day.
You as well.
I'm not threatening you. Say one more word and that's 30 days. 30 days.